firm for liberty.
Welcome to Deep Dive with the Institute for Justice. I'm Melanie Hildreth, and I'm here today with a special guest, IJ President and General Counsel Scott Bullock. Before he became IJ's president, Scott spent 25 years as an IJ litigator. That means he has had his share of memorable moments with clients, judges, government opponents, and more. We're going to talk about some of those today, as well as how those early years in the trenches influenced where IJ is now. So Scott, 25 years as an attorney, IJ's first attorney, our first case, our first client. Can you talk about that experience?
Yeah, it was a great experience, both kick off IJ, and it was also my first client as a lawyer, too. I was fresh out of law school, and we had the pleasure of representing two African hair braiders in the District of Columbia who were being told by the D.C. government that they had to get a cosmetology license to practice their profession, even though the cosmetology license had absolutely nothing to do with African hair braiding. So it was a classic IJ case on a signature IJ issue of challenging economic protectionism.
And a case that may sound familiar to many of our listeners because we still litigate hair braiding cases even today. So in that early case, were there things that you learned or that you experienced that later influenced the way that IJ approaches hair braiding cases or other economic liberty cases?
Well, it was, it's said, a great case. The clients were phenomenal. The issue was presented really well. We had a judge in D.C. who was a district court judge who was kind of a unique character. He was the former general counsel of the CIA. When we appeared before him, he used to like to lean back in his chair and stare at the ceiling, so you didn't even really know if he was still on the bench when you were talking to him. He was hiding behind this form. At one point during one of the hearings, as D.C. was presenting its case, he barked to the D.C. counsel, "This sounds like Soviet Russia." And so we thought, this is going to be a pretty sympathetic forum, and we were hopeful for it. But what we encountered was this sort of unbroken line of cases from the New Deal on that said basically in this realm of economic liberty, the government can do whatever it wants. And he saw that as that he had to essentially rubber stamp what the government was doing. And he ruled against us. And
even after being that skeptical.
Even after being that skeptical, because he was faced with this kind of decades of case law. And so that is what we faced in the early days of IJ, and we knew that we had to change that. And that has been a part of our mission since those early days up until today.
So you lost in court, but that's still something that, looking back, we regard that case on behalf of those hair braiders in D.C. as a victory. How did that happen?
Well, it imparted several important lessons. One is the real need to have sympathetic clients, which Taladin Ukta and his wife, Pam Farrell, certainly embodied. But it also showed the power of the court of public opinion, because as public interest lawyers, we don't just argue in court. We use all the tools of public interest law at our disposal, including highlighting this to the broader public. And this got a lot of attention. John Stossel, when he was on 2020, did a great piece about the case called Rules, Stupid Rules. And it embarrassed the D.C. government, and it led to a legislative change that got Ukta and Pam in business, and they're still in business today.
Well, and now fast forward 20 years, what is the landscape like for economic liberty in particular after all of those years of work in the trenches?
Well, it's been really transformed because of the long-term mission and vision that we had, where we took on these cases and slowly started building what's known in the law as a string site, where we started winning these cases and saying that the rational basis test, even though it is broad and gives the government a lot of power, is not limitless. And so now, flashing forward 20 years or so, we have a great series of cases that have protected economic liberty rights, said that economic protectionism is not a legitimate interest, and we've made really substantial progress. Still a lot more left to do, and we still have setbacks along the way at times, and courts refuse to recognize these rights at times, but the landscape is so much better than what it was when we started in 1991.
And a great illustration of that might be another one of those classic IJ cases, the case on behalf of the monks of St. Joseph Abbey. Can you tell that story, how you found the case, what the monks' experience was like, what they were facing?
Oh, yeah. I mean, this is another classic IJ case with extremely sympathetic clients, a group of
Doesn't get any better.
Benedictine monks. It's hard to find better clients than a group of Benedictine monks that were simply trying to sell homemade wooden caskets that they had made for their brethren for over 100 years. And being entrepreneurs, the way monks have always been, they saw an opportunity and started offering them for sale to the public, and were immediately issued a cease and desist letter by the State Board of Funeral Directors that has 9 members, 8 of which happen to be licensed funeral directors. So it was a classic case of economic protectionism. And so we heard about this case. I reached out to the monks and said, we'd like to represent you. We think this is outrageous. And they said, well, we're monks. We don't really like to sue people. And,
first instinct, maybe not to go to
maybe
court.
not to immediately litigate a case. So they said, well, we have a state representative that's interested, and we think maybe we can get something done in Baton Rouge this term. And so they went to the legislature.
Their pure hearts.
Exactly right. And going to the state capitol thinking that they're going to be heard. And they had one hearing at a committee. The Louisiana Funeral Directors organized, knew, of course, all the state legislators, had that one hearing, and then it died in committee. And so I said, well, how about now? He said, well, we're going to give it one more go in the legislature. Went up this time, legislation introduced. This time they didn't even get a hearing. And so then they came back to us and said, now we're ready to sue.
Perfect. And now in the meantime, they get that cease and desist order, and they're exercising a little bit of civil disobedience.
Well, that's right. And so what was great about that case, in addition to it being a kind of a classic economic liberty case for us, is that we litigated it, and they were selling caskets. And they asked us, so should we continue
Should we actually cease and desist?
Yeah, should we continue to do this? I said, well, there's certain risks that are inherent in this. If we would happen to lose, they might be able to go back and fine you for every violation that you did this. And they said, well, we feel really strongly about this and the Institute for Justice. We're going to continue to sell them. And so it led to these kind of great exchanges during the deposition of the abbot, who was the head of the monastery. And my colleagues, Jeff Rose and Darpana, and I were in the deposition. And the attorney for the funeral board was asking these questions. They knew they were selling these caskets, which infuriated the board and the funeral directors cartel in Louisiana. And he said, Abbot Justin, how many caskets have you sold during the course of this litigation? And as many people might know, when you do a civil deposition, you basically have to answer every question that an attorney asks you. The attorney can object to it. Your attorney can object, but you essentially have to answer. There's no judge there to rule on the objection. But one of the few things that you can not answer is on grounds of self-incrimination. So we're able to step in and say, Justice or Abbot Justin, you will not answer that question. I'm directing my client not to answer this question on the grounds of self-incrimination.
He pleaded the Fifth.
Right. He pleaded the Fifth, which is usually reserved for mafia dons and other things. And the abbot was just sitting there not saying a word for it. So we litigated that case from the trial court on up to the Fifth Circuit and got this great decision from the Fifth Circuit that struck down the licensing requirements and allowed the Abbey to continue to sell the caskets. The Fifth Circuit said that economic protectionism is not a legitimate government interest. And the great thing that happened from this case was not only a victory for the monastery, but it was a case that we could build upon and use in our economic liberty work. And it's also a case that others have used then too. And that's always what we try to do in our cases, win so advances our mission, but to set a precedent that can be used by other small businesses and even people that are outside of the realm of who IJ might represent, but it can still benefit them in taking on economic protectionism. For instance, Tesla is challenging a lot of exclusive franchise laws that still exist in states which don't allow companies like Tesla to sell directly to consumers. And they're able to use the St. Joseph Abbey case in advocating for open competition and free markets.
Oh, that's a kind of a surprise that monks it turns into more cars.
That's right.
Yeah.
And that's what we always look to do, is to set that precedent that can benefit not only our clients, but as many Americans as possible.
Definite ripple effect. Well, actually, that's a good transition to one of the other cases that I wanted to ask you about, which is one of your early First Amendment cases. I think people might not know that you litigated a First Amendment case. It was cutting edge in a couple of ways, including the fact that it involved this newfangled thing, the internet, right?
Yeah. So this is a case where we sued on behalf of a group of investment advisors and software producers against the Commodity Futures Trading Commission. And this was during the 90s when the internet was just taking off and email was really coming into the popular kind of use. And before, when investment advisors would offer their advice about what they think is happening in the markets, they'd do it in the form of a printed newsletter that they would have to produce, drop in the mail, sent third class, and several weeks later, some of their subscribers would get the information, and maybe it would be useful, but in many instances, probably not. But with the rise of technology, people were able to communicate instantaneously with folks who wanted to hear their opinion. So you didn't have to wait for a couple weeks. You could send an email or go to a website and have this sort of instant contact with people who were giving their advice about what direction they think the markets are going. So a lot of people think that's great. Government agencies often think, this is terrible. My God, what are we going to do about this? People might have instant communication. We've got to stop it. So the CFTC did something that was contrary to about 400 years of free speech jurisprudence, is that they said that in order to offer this advice, you have to have a license. You have to be licensed by the CFTC as if you were trading commodities on behalf of individuals. And all these people were doing were just offering their opinions about what they think is going to happen, and then investors were free to accept it, reject it, follow it, or not. So we were able to challenge this, and it led to this landmark decision striking down what the CFTC was doing, and it was an early precedent protecting free speech and kind of software development in the internet age.
Well, and it may sound a little bit familiar to listeners as well, because that idea of people offering advice, maybe making a living offering advice without being licensed, something that comes up in IJ cases even today. That's
exactly right. At IJ, we never just do these one-off cases where we kind of hear about an outrage and we feel like, we're going to just try to do something about it. It's always part of and tied to our larger mission and what we're trying to do to advance a particular rule of law. And so what we did in this case was really form the basis for our occupational speech work. And this is our first case in this area that we're still, as you mentioned, building upon today, where we're representing tour guides and diet coaches, because so much of occupations today are information and giving advice. And so this allowed us to establish a basis for challenging these restrictions on occupational speech, which has become a major part of our First Amendment work.
Well, moving to even maybe more well-known areas for IJ, and certainly for you, eminent domain, the Kelo case is probably the most famous of IJ's cases. You found Suzette, you brought that case. What people, and I suspect most of our listeners are probably pretty familiar with it. What they may not know is that was, as you said, we don't take these one-off cases. That was not the only eminent domain case we had. We had many cases at the same time as Kelo, prior to Kelo. And I wondered if you could talk about some of the most memorable or interesting eminent domain cases that were not the Kelo case.
Yeah. And Kelo is another classic example of what happens and how you can lose the battle but win the war. And I mentioned the Ukta case, the hair braiding case was an early example of that. Kelo was kind of the really key example of that, where we lost at the Supreme Court, but because we were using all these other tools of public interest law, we were able to transform the world really in a very fundamental way that curtailed eminent domain abuse. But you're right, Kelo is the one that got a lot of the attention because that's the one that rose up to the Supreme Court. But myself and several of my colleagues, in particular Dana Berliner and I, did a whole range of these eminent domain cases because we never quite knew which one was going to eventually get to the Supreme Court. So we tried to take on as many as we could. And some of them went as far as state Supreme Court decisions. Others sat settled before they ever got that far with it. But we took on a number of them, including in my hometown of Pittsburgh, where the mayor of Pittsburgh in the late 1990s wanted to condemn a fifth of downtown Pittsburgh, destroy 60 buildings, remove 120 businesses to put in an urban shopping mall. He thought that was going to be the key to Pittsburgh's revitalization.
So you fast forward 20 years, looking back, that sounds so crazy.
It's crazy. And they look at the state of retail today, look at the state of shopping malls. And so we said we were going to represent the property owners, and they were classic Pittsburgh types, a lot of locally owned businesses that had been there for a number of years. It got a lot of attention. We put up billboards. We threatened legal action, and the mayor eventually backed off. But you're right. Could you imagine if he would have followed through with this? What a disaster this would have been in downtown Pittsburgh, which is now actually having a renaissance of its own, oftentimes by bringing in other businesses and attracting them organically rather than this kind of top-down approach. We did a case in Long Branch, New Jersey, where we represented a wonderful group of homeowners, and this was a case where the government was taking homes for homes. So they were condemning these small beachfront cottages where people would live for a number of years to put in high-end condominiums. And it just showed kind of the outrage of it, the reverse Robin Hood that exists in eminent domain cases, and we were determined to put a stop to it.
And that exactly what we warned in the Kelo case and others would happen was happening, that you could take from one private property owner and give it to another one just because it was a fancier house.
Exactly right. Yeah. And so there was another case that we did that I was really near and dear to my heart that in Mississippi too, and that was a case where we took on the entire state establishment there that had promised land to the Nissan Corporation to build a new facility in the state, and this was wired from Trent Lott down to the governor to the local political players for it. But it was going to impact a family that had lived on this land since the 1940s, the Archie family, an African-American family who this was their first land that they ever owned. Before that, their family was sharecroppers. Before that, slaves. And so this land meant everything to them. And it wasn't even going to be used for the facility itself. They could build that further up the road. They just wanted to have this for storage and landscaping and that sort of thing. And they owned about 20 acres. It was classic family-owned land. The Archies lived on it, and cousins lived there. The roads in the area were named after the Archies. And so this was just a group of family members that were so dedicated to this land, and they wanted to stay. And we said, we are going to challenge this and put a stop to it.
Sounds like it was an especially tight-knit community. I mean, so many of these communities are quite close. That one sounds especially so. Were there things that you did to gather people together and to kind of keep them inspired as they're facing these incredible odds, if you're saying from the top of the government all the way down?
You're right. I mean, this was just family-owned land. And then we worked with a number of people in the local community that wanted to support the property owners. We worked with a civil rights activist by the name of Stephanie Parker Weaver, who was known in Mississippi as Sister Hurricane, that would kind of come into communities and really make sure people's rights were protected. And we worked very closely with her and really highlighted this. We got a great front page story in the New York Times about what was happening here, and really drew attention to this outrageous situation that had the support of the public, and the Archie certainly had the support of the public. But as I said, the entire political establishment was wired against it. We actually brought in Martin Luther King the third. Stephanie knew him, and he came in for a prayer vigil the night before we had our hearing in the eminent domain case. Which
brings us to one of my personal favorite Scott stories, the story of that vigil and kind of the unlikely cast of characters, from the IJ libertarians to the civil rights leaders to a Swedish intern.
Well, this was just one of these kind of what we call kind of IJ moments. And so it was an incredibly touching evening before we had the hearing. And we had this wonderful rally at the church. We joined hands at the end and sang "We Shall Overcome." The parishioners that were there to support the Archie family. And we had this fellow that was with us named Gunnar Stromer, who was from Sweden and was studying kind of our approach to public interest law. And he was this very large Swedish guy, looked kind of like a Viking. And he said, "Could I come to this vigil? I'd love to be there for it." And we said, "Okay, come on down." And he wanted to help out. And he said to me, "What can I do?" And so we were at the church, and I realized nobody was handing the parishioners a program as they were coming in, and he said, "Oh, I'll do it." And then it was one of those things where I saw from a distance kind of these people in kind of a rural part of Mississippi going into this AME church, and this very large Swedish man was saying, "Welcome, welcome to you," and it was
like, where are we?
Exactly. They're looking up and like, what am I? What's going on with it? And so we were able to do this vigil. It was before an 18-hour hearing in court. This was something that the judge insisted on doing because contracts had to be met, and that there was huge pressure on the state for doing this. And so we started at 8:30 in the morning, and we ended at 2:30 a.m. the following day. 18 straight hours. One of the Andrew Archie, kind of the family patriarch, he was diabetic. He collapsed in the courtroom about 8:30. We said, "Judge, he needs to testify." He said, "Somebody else can testify on his behalf. Get going."
Wow.
And so we concluded at 2:30 in the morning. I said, this is not a very good sign that they was insisting on doing this all in one day. We lost at the trial court. The judge, in his opinion, started his opinion with the Book of Common Prayer, a quote from it, which essentially the message was, "Forgive me, God, for what I'm about to do," and ruled against the Archies for it. So what we did was we got an emergency stay from the Mississippi Supreme Court. We did this in a huge hurry, but the Mississippi Supreme Court stayed the condemnation proceedings. And then all of a sudden, miraculously, the state said that they could build the plant without the Archies' land, even though they had testified under oath in court during the 18-hour hearing that there was no possible way they could do that. And so they found a way because they had to move on, and these decisions had to be made. And so the Archies were able to keep this land where they're still on it today. The incredible stories of the clients actually brings me to the last sort of thing that I wanted to talk about today, which is, you worked with the monks, you worked with the Archies, you worked with Suzette. You also you've just found some of our most really cool, incredible clients. One of whom was the client in our the first case as part of our forfeiture initiative, which you started in 2010 and really now is still gathering steam, but has reached crescendo with the Supreme Court victory. Can you talk a little bit about Russ Caswell and his case and how you knew that was something that could be bigger than this one person? Yeah, I mean, the Caswell case represented everything that's wrong with modern-day civil forfeiture laws. This was a case where the Caswell family owned a small family-owned motel in Tewksbury, Massachusetts, and never had any problems with the law. And then, shockingly, at a budget motel over the course of several years, some people engaged in drug activity there. Surprise,
Which never happens at the Ritz-Carlton.
Oh, never happens at that or the Motel 6 down the road or the Fairfield Inn or all the other places that we documented had just as many problems, if not more, than the Motel Caswell. But what the Motel Caswell had was a property that was free and clear of any liens, mortgage interests, or anything like that.
And no corporate lawyers.
No corporate lawyers for it. And if the federal government and the Tewksbury Police Department were successful in this forfeiture, they could have gained a nice commercial piece of property that was worth about $1.5 million free and clear because the Caswells had owned this property since the 1950s. And they were making the argument that it doesn't matter whether the Caswells are guilty or innocent. People had used the property to facilitate illegal activity, and so that was enough. And so we heard about this case. A family lawyer was helping the Caswells in this situation, and he didn't know much about forfeiture, so he contacted us and said, could you give me some guidance and some information about this? I got the email and said, we've got to do something about this, and flew up and met the Caswells, and it went on from there.
At the trial, did you actually take the judge to their home as part of the? How did that come to happen?
Yeah, so we did a site visit to the home and saw the home was actually right next to the motel, and they were kind of making this argument that the Caswells were kind of negligent in letting this go on, and so we always tried to work with the police, as they always did, and they had a real interest in not having a lot of illegal activity occurring because their entire family lived next door to the motel, including Russ's granddaughter and his son and his family had lived with them for it. So yeah, we did an on-site visit to them, and it was one of these cases where we knew we had to win. Mm-hmm. As the case went on, it was the U.S. Attorney's Office that litigated it. It was a case where if they would have won, 20% would have went to the federal government, 80% would have went back to the Tewksbury Police Department, giving them a vested interest, a huge stake in the outcome of this. They knew they had a really tough case, but we said, drop the forfeiture action. Then the case is solved. They refused to do that, but they kept making more and more generous settlement offers to Russ, to the point where they were basically saying, hey, if you just sell the motel and give us a couple $100,000, we'll go away. And you face the loss of everything, and then you could maybe get out of this with $1.3 million, something like that. And so the pressure was on him, and Russ said, no. Not going to settle. I couldn't live with myself if I did that because I have done absolutely nothing wrong. And those are the type of people that we represent. And we knew, though, at that point, we had to win this case because Russ was risking everything. This was his retirement. This was his 401k, basically. So he's either the family was
his legacy to his family, his own children.
Exactly. We were going to keep running the motel, or they were going to sell it and then use those proceeds for their retirement. Russ was close to 70 years old at that time. So he really put his family's fortunes and their future on the line
and in your hands.
And in IJ's hands. That's right. No pressure at all with it. And so we knew we had to win. We did a 4-day trial in U.S. court in Boston. And thankfully, the judge saw through what the government was doing. I think was frankly appalled by the behavior of the government and bringing this action. And she kept waiting. You could almost see her expression as she heard the testimony in this case, thinking, this is it? Mm-hmm. This is all you've got? She was thinking, well, maybe Russ was in on it or somebody knew what was going on with it and some kind of bombshell testimony was going to happen. And it was just a parade of people acting behind closed doors that Russ had no idea what was happening with it. And their argument was that this was enough. And the real problem with civil forfeiture, of course, is the law is written in a way that does give the government this power to do these types of forfeiture actions. And so we were very thankful that the judge ruled in our favor. We're now using that precedent in other cases, but it was an example of what happened when you have these open-ended laws. It lends itself to this type of abuse.
So how did you know, was there a point in that case or shortly thereafter where you realized that how widespread forfeiture is, that this is something that is going to be, it is now a major part of IJ's work? At what moment did you get to that tipping point where you're like, this isn't just a few cases dealing with an outrageous thing. This is an entire campaign. This is an initiative.
Well, it was an issue that we've been following for a number of years and really investigating thoroughly. There was some outrage about civil forfeiture in the 1990s, and there was some pressure on Congress to change the civil forfeiture statutes at the federal level. This led to the passage of what's called the Civil Asset Forfeiture Reform Act of 2000, and it did make some improvements to the law, but it's typical what happens in a lot of these situations is kind of attention's focused on it, and then people say, well, problem solved, we'll move on to something else. But the fact of the matter is that a lot of the problems were not solved, in particular, the perverse financial incentives that exist in the law. And so forfeiture continued. It kept growing. More forfeiture powers were given to the federal government, a lot of state governments in the wake of 9/11 and kind of the upstart of the war on terror. And so this was just a growing problem, a multi-billion-dollar-a-year industry for government. So we knew we had to do something about this. We put together a comprehensive program that was not just key litigation, which was a major part of it, but it was also issuing a major strategic research report that we did when we launched the forfeiture initiative called Policing for Profit, that we're now working on the third edition of, and used everything at our disposal to shine a spotlight on this, to take what was at once a relatively obscure issue that affected, though, thousands of property owners and shine a national spotlight on it. And that's where we are today. We've made a lot of progress on the issue, but this remains a huge revenue generator for law enforcement agencies throughout the country. And so we are still working throughout the country to try to further curtail civil forfeiture laws.
Well, thank you so much, Scott, for taking the time to share the memories, the insights, recollections of how IJ became the force for freedom that we are today. With that, we're out of time. Thank you for listening. If you enjoyed the conversation, please be sure to let us know. Don't forget to follow and to subscribe. The
Institute for Justice.
The National Law Firm for Liberty.
Welcome to Deep Dive with the Institute for Justice. I'm Melanie Hildreth, and I'm here today with IJ President and General Counsel Scott Bullock and IJ Senior Attorney Bob McNamara. We're going to talk today about immunity. So immunity is a term that's probably familiar to Deep Dive listeners who have also listened to IJ's podcast, Short Circuit. It comes up a lot when they're talking about cases where someone feels that the government or a government official has violated their rights, and they're going to the court and asking the court to hold that person accountable. For people who aren't familiar with immunity and the way that it plays out in those cases, Scott, do you mind starting us off with a little primer?
Sure. I should probably start off by reminding folks of how difficult it is to sue the government in general. And this is true for even our most basic cases that we do at the Institute for Justice when we sue for what's called declaratory and injunctive relief. And that's basically when you're just asking a court to declare that what the government is doing is unconstitutional and to enjoin them, to stop them from enforcing that law. Because there's all kinds of things you have to overcome. The government has a presumption of constitutionality that works in its favor. They, of course, have the deep pockets of the taxpayer to draw upon. So it makes it very difficult for the average citizen to sue the government. And it's one of the reasons why a group like the Institute for Justice exists. It's one of the only ways that a person has to really vindicate their rights. On top of that is the doctrine of immunity, which makes it, in many instances, almost insurmountable for people to hold government accountable and to get monetary damages, even when the government egregiously violates their rights. And there's all kinds of different doctrines of immunity. There's absolute immunity that typically applies to judges and unfortunately to prosecutors. And then there's the doctrine of qualified immunity, which is what probably a lot of people are familiar with, which also makes it extremely difficult for citizens to hold government officials accountable. And this is very different than what private citizens face. If you violate someone's rights or you hurt them in some way, you are held accountable for it as just an average citizen. not the case with the government. Government officials have immunity, and citizens then have to overcome that immunity. And so that's one of the reasons why we launched IJ's project on immunity and accountability. And it starts with a very simple but fundamental premise that if citizens must follow the law, which government always is reminding us citizens are obligated to follow the law, then government officials must follow the Constitution. And if they don't, they have to be held accountable for it.
The idea that a government official could be completely immune or even partially immune, for most people will probably sound kind of crazy in a government and in a system where the framers were clearly so conscientious about setting up checks and balances and other ways to kind of limit government's ability to infringe on people's rights.
Well, it's right. I mean, there's the immunity doctrines are nowhere in the Constitution. They're basically judge-created doctrines that shield government officials from accountability, but you won't find it mentioned anywhere in the Constitution and really not in any laws. And many laws, like Section 1983 that some people might be familiar with, actually give a right to citizens to sue the government to hold them accountable.
So if it's not in the Constitution, it's not in the law, and in fact, the opposite's in the law, where did this idea come from? How are we in the place where we are now?
I mean, it comes from the courts. I mean, the modern doctrine of qualified immunity really starts in the early 1980s in this case called Harlow v. Fitzgerald. And the plaintiff in that case had alleged sort of a vague, shadowy conspiracy. He was a government employee and said that a bunch of figures in the Nixon administration were conspiring with each other to prevent him from continuing in his job. And the court is clearly uncomfortable with kind of the vagueness of the conspiracy that's being alleged. But the court also says, look, even if all of this is true, it's not totally clear to us whether this sort of activity is illegal in the first place, and we're not going to hold someone liable unless the constitutional rule they violated was clearly established. And in a certain sense, I think framed at that level of abstraction, the idea of qualified immunity appeals to a lot of people. If the Supreme Court is going to announce a brand new rule for the first time, it seems kind of unfair to say you're going to be liable for breaking this rule that literally no one knew about until we announced it just now. But that's not really what the doctrine means in practice.
Right. So how does it play out? There's some pretty crazy stories of how this works for the average person interacting with government officials.
Right. And so what the doctrine has morphed into since the 1980s is not just we're going to let you off the hook if we announce a brand new rule you couldn't possibly have known about. What it's morphed into is this idea that for a rule to be clearly established, you have to find a federal appellate case saying that exactly the conduct the government official engaged in exactly the circumstances he engaged in it in, was unconstitutional. And if you don't have a case on point, the law can't be clearly established, and therefore you're entitled to qualified immunity. And it leads to absurd results. There was one qualified immunity case where it was clearly established. There was an earlier appellate case that had held it was unconstitutional for the police to sick a dog on a surrendering suspect. And so someone else sued and said, well, I was surrendering and the police sicked their dog on me. And the appellate court actually said, well, the first guy was lying down and you were seated with your hands in the air. And those are just different circumstances. And so the police are entitled to qualified immunity. It's literally the physical position. Or in a separate case, a property owner alleged that the police, while serving a warrant, just stole a bunch of money and rare coins, just kept it for themselves, just pocketed it, never delivered it to the evidence locker. And when the property owner sued, the Ninth Circuit Court of Appeals said, well, there's no case saying it violates the Constitution for the government to steal things from you. And so we have to award qualified immunity. And the court in that case actually goes out of its way to say, like, we recognize, like, generally speaking, human society recognizes
2,000 years of moral traditions. That's right.
Exactly. But there's no federal appellate case. And it's really this doctrine that it treats government officials as these sort of moral monsters who can only obtain instruction from published federal appellate decisions, which is not true. I mean, they're not moral monsters, and it's also just not true that the only source of kind of moral or legal education is the published opinion of a federal appellate court. The people who are supposed to teach you not to sick a dog on someone who's sitting down with their hands in the air are not the federal appellate courts. They're your mom and dad. That's just a thing we can all understand.
And it should go. It's different than what the normal citizen faces, which is the reasonable person standard. That's
right.
What you face is what would a reasonable person act like in this set of circumstances. But Bob's absolutely right. Here, it's this question of, is there clearly established and exactly on point precedent that gives the government officials fair notice about this?
And the end result of this is really the erosion of incredibly important rights, which I think is maybe best illustrated by Shanice West, who's an IJ client that we're representing right now in front of the U.S. Supreme Court. And Shanice came home one day to find her house surrounded by 5 officers from the City of Caldwell Police Department. They had surrounded the house, and they told her they were there looking for her ex-boyfriend. They asked if the ex-boyfriend was inside. And Shanice said no. I mean, he wasn't supposed to be. She hadn't been inside the house. She'd be surprised if he was there, but he's not supposed to be in there. And they ask if they can go in and apprehend him if he is there. So Shanice nods her head, hands them her keys, and leaves. But they don't use the keys. Instead of using the keys, they call in the SWAT team, set up a perimeter around Shanice's house, and engage in about a 10-hour standoff with the house, where they spend a bunch of time launching tear gas grenades from shotguns through the walls and roof of the house. At the end of the day, they finally enter the house, they tear through the walls, and they realize that Shanice was telling the truth all along, that her ex-boyfriend wasn't in the house, and they've just engaged in a 10-hour standoff with a house that was empty except for Shanice's dog, Blue, who survived.
Unbelievably.
But the house, Blue was okay, but the house was ruined. Shanice was homeless for 2 months. They had destroyed essentially all of her worldly goods. The house was uninhabitable. And so she sued, and she sued because, generally speaking, if the government is going to come into your home, if it's going to seize your home or search your home in this way, it needs a warrant, right? That's a common bedrock property rights protection. If the government wants to come into your house, they need a warrant. And the government said, well, wait. We didn't need a warrant because we had your consent. We had your consent to go into your house. Now, no normal human being thinks consent to go into someone's house is the same thing as consent to destroy it from the outside. We've all invited people into our houses. We've had dinner parties. Our dinner parties are not a secret invitation to stand on my sidewalk and shoot grenades into my windows. But the appellate court looked at it and said, well, wait a minute. No one's ever made this argument before. No one has ever come into a federal court and said consent to go inside someone's home is the same thing as consent to blow it up from the outside. And so since there's no federal case on point telling us that consent to go inside isn't the same thing as consent to destroy, we have to award qualified immunity. Now, we're not saying what they did was reasonable. We're not saying that a competent person would think what they did was legal. We're just saying there's no case on point. And what that does is it takes what's supposed to be a tiny exception. Like there's this general warrant requirement, and there's an exception to the warrant requirement when you have consent to go inside. And it says, okay, we're going to draw this narrow exception to your property rights, but the boundaries to that narrow exception are going to be governed by qualified immunity. So as long as the government manages to violate your rights in a way that nobody has thought of before, they're going to get off scot-free. And that means that any exception to property rights, any exception to a warrant requirement is going to be automatically boundless as long as you can come up with a new way to break the rules.
And the perverse consequence of this, as Bob points out, is that the more outrageous the conduct, the more likely it is that the government is going to get immunity because nobody had ever thought to issue a decision about this before. And so that is just one of so many problems with the doctrine.
So to a normal person, these examples are so absurd. You know, the lying down versus standing up, the stealing coins, throwing grenades at somebody's house because you said that they could use a key to go in. Do you get the sense as you've looked at these cases and other cases that judges are ever a little bit embarrassed to be taking these sorts of positions? You know, how do they justify to a normal person this whole concept, you know, the idea that this is permissible?
You absolutely get that impression. And I think that's the reason the Ninth Circuit in the coin theft case has a whole passage about how they understand that theft is wrong. And usually if you have to say out
We
loud,
know better. The cops don't know better, but I know better.
Wrong, it shows shame. The only reason to say that out loud is you're a little bit ashamed of what the law is forcing you to do. But there are a number of opinions from lower court judges just openly saying this doesn't make any sense. I have no idea what it means to be clearly established. I just don't know what that means, and I'm going to sit here and I'm going to apply the law the Supreme Court told me to apply, but I want to tell you up front, I don't know what that means, and I don't know what I'm doing. And what it leads to is essentially arbitrariness, that it's sort of all within the discretion of the judges how closely a previous case has to match the current case in front of them. Does it make a difference if someone was lying down or sitting down or standing up? What if they were touching their nose? And so there's no coherent way to predict in advance, this case will yield qualified immunity, this case will not yield qualified immunity. And so it results in a lot of uncertainty both for citizens and frankly for government officials and for courts, and a lot of impunity, a lot of clearly incorrect actions by government officials, things that no one will defend on their merits, that nonetheless don't yield any kind of actual accountability for the government or any kind of relief for the property owners or other people who've been victimized.
So the final outrageous case, the example that you gave, the Shanice West case, is an IJ case. It's the first one of this kind of case that we took on. Scott, you mentioned earlier the project on immunity and accountability. Could you talk a little bit about why this is something that IJ decided to tackle and why now?
Sure. This is something that we started to encounter in some of our own cases, too, where these doctrines were thrown at us, especially in the civil forfeiture context, where we have a number of cases challenging civil forfeiture for it. And it was also something that myself and several other attorneys at IJ noticed was happening in the law. And we said this is something that maybe a lot of the general public doesn't know about, but it's something that's so pernicious that it merits our attention. And we can look at it from a way that looks at first principles, too, to talk about the need for government accountability and why this doctrine is not well founded in the law as well. And so we do what we often do in these situations is we take issues from relative obscurity, use all the tools of public interest law to shine a national spotlight on them. And we have done that for eminent domain abuse and civil forfeiture and occupational licensing and educational choice. And that's what we were determined to do with qualified immunity then as well. And so we started doing more research into this. We held a roundtable where we brought in practitioners in this area, academics, people who knew a lot about this. We started to develop our own expertise through the filing of amicus briefs in these cases and really staking out our position on this. As listeners of the Short Circuit podcast know, qualified immunity cases make up a large percentage of the dockets of federal courts, and so we started talking a lot more about it in that forum. And then we said we're ready to now go forward with original cases on this. And so we launched it with the Shanice West case that Bob talked about, and now we have several cert petitions before the court on this. And the timing of it is really right as well. As Bob mentioned, there is this growing consensus that this doctrine is, as I said, not grounded in the law and is leading to these horrible abuses of people's rights. And so it's almost reaching a tipping point where the courts are going to have to address this, and we're providing them with great opportunities for them to take up the issue.
And to the extent that people outside the legal system are looking at it, they're starting to look at it more skeptically as well. Doesn't Bernie Sanders actually talk about this in some of his campaign stump speeches?
Well, and that's the other strength of this, and it's true of so many IJ issues, is this sort of consensus across the ideological spectrum that this is a real problem. So our friends at Reason Magazine and the Cato Institute have been speaking out about this and doing great work there. Judge Don Willett, who was an appointee by President Trump to the Fifth Circuit, has been outspoken about the inequities of qualified immunity. Justice Clarence Thomas has also spoken out about this, Justice Sotomayor. And then you have the the platforms of people like Bernie Sanders and Elizabeth Warren that also said something has to be done about qualified immunity. So that's always a really good sign.
Potentially the only thing that National Review and Bernie Sanders agree on is...
That's right. And David French, who used to be at National Review, has written a lot about this. So all these people that don't agree on a lot of other things say this is fundamentally wrong and something needs to be done about it.
So where do we want the law to go? What are we trying to get through these cases, through the advocacy, the education, the things that IJ is doing? Where do we want to end up, Bob?
What we're trying to achieve is a system where courts can do what they're designed to do, which is hold the government accountable when the government violates the Constitution. The first step in having a limited government is actually enforcing the limitations on government. And in our country, those limitations come from the Constitution. And at bottom, I think this debate is a question about whether the Bill of Rights and the other amendments to the Constitution are empty promises on a piece of paper, or whether they're meant to have meaningful effect in the real world. And if they're meant to have meaningful effect in the real world, that means courts have to be empowered to do something when you break them. And right now, in most situations, they're just not. Right now, the consequence to a government official who violates your property rights, your Fourth Amendment rights, your Fifth Amendment rights, your 14th Amendment rights, is all too often going to be nothing. And not because what they did was okay, not because you weren't harmed, but just because it hasn't come up exactly like this before. And that's no way to run a railroad. That's just no way to have meaningful, enforceable protections for individual rights. And so what we're trying to do is move the debate and move the activity back to where it belongs, and that is on the Constitution and the deeply meaningful promises of individual liberty contained in the Constitution.
So I'm going to throw a couple potential objections at you, and I want to get your responses to them. So if somebody is perhaps not totally sold on the idea that qualified immunity is crazy, one response might be, from the perspective of the police, maybe, if they don't have this assurance that they are going to be protected for behaviors where it's not clearly established, won't they change their behavior? Would they pull back? Would they not take action when maybe they should? And as a result, people could be hurt or property could be damaged or things could go badly in ways that they wouldn't, if the police had that assurance.
So I can understand that concern, and I do hear that a lot, but I think that's also just a very strange way to think about how police officers conceive of their job. Like, I just have a hard time believing as a practical matter there is any government official, police officer or otherwise, who before they make a decision says, wait a minute, wasn't there an 11th Circuit U.S. Court of Appeals decision on this 4 years ago? Sort of the fiction of the qualified immunity doctrine is that that's how the police make their decisions. They're intimately familiar with the details of published federal appellate decisions and use them as their guide in all things. And it may be unfortunate news to the judges whose job it is to write those federal appellate decisions, but that's not true. Law enforcement doesn't know every jot and tittle of those opinions. And so it's not really giving any kind of assurance to government officials or to law enforcement to have this doctrine because they're not making their decisions based on those federal appellate decisions. They're making their decisions based on what they think is reasonable in the moment. They're making their decisions based on their training and their competence. And what we're asking for is a standard that looks to their training and their competence. And I think Shanice West's case is a great example of this. The court in that case disavowed any holding that what these officers did was reasonable. They disavowed any holding that a competent officer could have understood consent to go into the home as consent to destroy it from the outside. And instead, they said the only question was this very technical quest for an on-point, earlier published federal appellate decision. And we say the test should actually be competence. Would a reasonable officer in your shoes have thought he was allowed to do what he was doing? Could a competent officer have made the decision that you made? And that actually provides a lot of leeway for the government already. In many other areas of the law, the way we govern things is by asking, would a reasonable person have done what you did in that situation? That's how we govern everything from car accidents to slipping on ice. Would a reasonable person have done what you did in that situation? And that, for centuries, has proven to be a pretty good way of adjudicating things without leaving us all in fear of what's going to happen in the event of a lawsuit. And that's really all we're asking for here. It's not that government officials have to be perfect. It's not that government officials can't be required to make decisions. It's just that courts, instead of engaging in this artificial inquiry, courts have to look at whether the decision they actually made was reasonable.
And that kind of get to Scott's point from earlier that this happens already for private citizens all the time. That's the way that courts look at things in those instances. So other objection, let's say then again that qualified immunity is curtailed, not on the table. You can hold government officials accountable for damages, and then they end up obligated to pay you money, perhaps the amount of money that you spent repairing your house after they shot a bunch of grenades into it. Who ends up bearing that cost? Like, couldn't there be some concern on the part of the ordinary taxpayer who had nothing to do with the grenades and would completely have agreed that they are unreasonable, feeling that they then are on the hook for this kind of crazy action that the government, that the government decided to pursue?
No, that's absolutely a valid concern. And fortunately, there's research on this. And what the research shows is that these things are insurable. When a court does award damages to a property owner or a victim in these situations, that money doesn't come from the government officials, and it doesn't actually come from the government itself. It doesn't come out of the government's bottom line budget. It comes from insurance. These are insurable risks that can be covered by an insurer. And the idea of holding people liable is that one thing insurance companies are very good at doing is identifying risk. Is identifying, you should really maybe have a training program that says not to launch grenades into houses, because it turns out to be pretty expensive for us when your guys launch grenades into houses. And shifting the burden from the individual victim whose constitutional rights have been violated to an insurance company or to the government itself if it decides to forego the insurance company allows the liability to be in the hands of the people who actually have the power to stop the constitutional violations from happening. And so the goal is not for there to be a whole host of money judgments that people have to pay. The idea is to actually have fewer violations of the Constitution in the first place.
Get them to stop doing what they've been doing.
So Scott, what do you think our prospects are as you look at this? This is a very big challenge. How do you foresee things playing out over the next few years and perhaps even longer?
Well, it's definitely an uphill battle, as all of our projects are at IJ. But as the old song says, there's something in the air. And this is an issue that is really reaching a crescendo right now of concern about this. As we mentioned, there's this widespread consensus across the ideological spectrum that something ought to be done about this. And so we feel like even though there's big challenges to this, courts don't like to reverse course on many of these doctrines that have been established now for close to 40 years. We really feel like because of this consensus that is being reached and the fact that this does not have any solid foundation in the law, that we're going to get some really good results from some of the cases that we're filing in the lower courts. And eventually the Supreme Court is going to have to address this. And I think it's going to be relatively soon. Now, will they address everything in one opinion? Probably not. The courts typically like to work incrementally, but we're going to look for every opportunity to give the Supreme Court and then the lower courts the ability to start curtailing this doctrine, to instill more accountability in government officials, and to protect the rights of the average citizen.
Well, thank you so much for being here and for taking the time to talk through this issue, because it is a pretty complicated one. Thank you, too, for joining us for a deep dive into IJ's work. You can get more episodes of this program wherever you get your podcasts or on YouTube. And don't forget to subscribe. If there's an IJ issue you'd like to learn more about, email me at melanie@ij.org, and we may feature it in a future show.